vehicle unless you have a valid driver's license. So no driving unless driver's license. You will be allowed to remain in England in the UK during the pendency of this matter, unless told otherwise. So if Judge Brian or whoever orders you to come in person, that's order of the court. You must follow the first court date. It's going to be Zoom, but if it does change, the judge will let you know, and you'll be required to attend any court dates as ordered. Is that understood, Mr. O'Barra?
Understood, Judge.
Okay, Mr. O'Barra and counsel, any questions on court dates or bond conditions?
No, Your Honor, thank you.
You're welcome. All right, good luck, counsel. Mr. O'Barra, you as well. Take care. You're welcome. You're free to go, Mr. O'Barra. Hickman, we're just still waiting for the DDC to zoom in, so we'll wait. What's your name?
I'm John Borgnowski. I'm appearing on behalf of Andre Clark.
For Andre Clark? You're his attorney?
No,
Where's Andre Clark? Where is he in, like, the physically? Is he getting fingerprinted?
oh
yes, he is.
Okay, thank you. We'll handle him as soon as he gets back. Charles Davis,
Yes,
are you ready?
no, I'm waiting on my attorney.
Okay,
Mays.
Mr. Mays,
Yes, William Mays.
William Mays. When I get here, you let us know and we'll handle the matter, okay?
Thank you.
You're welcome. Milton Burks. Is he getting fingerprinted as well? I didn't sign any fingerprint orders, so I don't know how this is all happening. Milton Burks,
Horton and Clark is getting,
what's it?
Horton and Clark is getting fingerprints.
Okay, thank you. What about Milton Burks?
Your Honor, I was told by my law partner that Mr. Burks at some point was at the information desk, and then I couldn't find Mr. Burks.
I'll hold it. If we find him, you let me know.
Yeah, and it says in person, so I don't know where he was directed. He was
Okay.
here, he went to the information desk, and I don't.
Okay. Well, I'll hold it.
Thank you, I appreciate it.
Yep. Right, and then, if we can have DDC call in, that's what we're waiting on. Oh, thank you. Thanks. And then once we get the females up, we'll call chief.
The fingerprints.
No, no worries. Okay, cool. Morning, council. You ready? You're representing Mr. Davis?
I'm sorry?
You're representing Charles Davis?
Yes, I am.
Do you need a moment to speak?
No.
Come on up. Again, good morning to both of you. Mr. Davis, your full name, please.
Charles Cornell Davis.
Thank you. For this case, 25044-289, People State of Michigan versus Charles Cornell Davis. Appearance for the people.
Samantha Coyle, appearing on behalf of the people. Good morning.
Thank you. Good morning, Ms. Coyle.
And good morning, Your Honor. William Mays on behalf of Mr. Davis.
Can I get your P number, counsel, for the computer?
P56406.
Thank you. As to the arraignment,
We'll waive reading, ask the court to enter a not guilty plea.
thank you. Have you advised your client of his constitutional rights,
I
correct?
have.
Thank you, counsel. Court waive formal reading and plea of not guilty. Mr. Davis, I'm scheduling a pretrial date via Zoom. You must attend on June 27th. That's the last Friday in June, 8:30 here at the 36th District Court. Judge Jones. Understood, sir?
Yes.
Not guilty, please enter on your behalf. As the bond from the people,
The people are recommending a 10,000 personal bond, no alcohol. During the pendency of the matter, the blood alcohol level in this was a 0.096. This occurred back in May of 23. I'm not aware of anything prior or any OWIs subsequent to this. And there is no KPS history, so no objection to 10,000 personal. Thank you.
thank you.
I would have an objection to that. I would ask though, 27th, I'm in a jury trial.
Okay, so that's the date we were given. If you can reach out to Judge Jones and speak with her staff, they can hopefully accommodate you.
Yep,
right.
Okay, thank you.
You're welcome. So, Mr. Davis, I've heard advocacy from the people without objection from your counsel. I'm also unaware of any criminal history, assaultive or otherwise. You've surrendered yourself with good counsel. I take that into consideration that you walked into the court to address this matter that took place back in 2023. Charged as a misdemeanor. I've reviewed the investigator's report. Given the allegations of the high BAC and the concerns that gives the court, I am going to file the recommendation from both parties with these conditions. You'll be released on a $10,000 personal bond for the concerns placed on the record. There is no use of any alcohol while on bond, and you're not to drive any vehicle unless you have a valid driver's license. Do you understand?
Yes.
Counselor, Mr. Davis, any questions on court date or bond conditions?
No,
Good to see you. Counselor, Mr. Davis, you'll just have a seat. Officer Brownlee will get you some paperwork.
Thank you.
Thank you.
You're welcome.
Thank you.
You're welcome. Thank you. Morning, sir. Morning, Your Honor. You're Mr. Horton,
yes, sir.
and counsel, you're on the felony matter, is that correct?
Yes, Your Honor.
Okay, so Mr. Horton, once you finish, you also have a misdemeanor matter that we're going to handle after counsel represents you on the felony. So have you spoke with defense counsel regarding the misdemeanor matter, other counsel? No, so once we finish with this, I would like you to speak with another attorney for representation on the other matter, okay? All right. So if Mr. Reagan or someone from your office could interview Mr. Horton on the misdemeanor matter, I'd appreciate that. All right, so on the felony allegation, Mr. Horton, state your full name, please.
Michael Allen Horton.
Thank you, sir. And this is on case 230-55553, People State of Michigan versus Michael Allen Horton. Appearance for the people.
Morning again, Lisa Coyle appearing on behalf of the people.
Yes.
Your Honor, good morning to the record attorney Richard Cummings on behalf of Mr. Horton. Magistrate, I have an appearance here. Actually,
Absolutely. Thank you. Give it to the court. Thank you. Good morning. As to the arraignment, counsel.
waiting for reading of the charge, stand mute.
Thank you. You've advised your client of his constitutional rights. Is that correct?
Yes.
Court waive formal reading under plea of not guilty. Gentlemen, I'm scheduling 2 court dates. Mr. Horton, you must attend both. Probable cause via Zoom on Thursday, June 26, 8:30, 36th District Court, Judge Giles, June 26. You have a right to a preliminary examination in person the following Thursday, July the 3rd. It'll be in person, 8:30, Judge Giles. Do you understand the court date and times you must attend?
Yes.
Thank you. Not guilty. Please enter it on your behalf, sir. That's the bond from the people, APA.
People are recommending a 10,000 personal bond, no contact with the complainant, Mr. Thomas, in this matter. This matter dates back to January 2021. It was not signed actually until 2 years later, and here we are 4 years later. I'm not aware of any unwanted contact, and no other case has been picked up since then, Your Honor, other than the misdemeanor that he's here on today. I do not see a criminal history for him, so no objection to a 10,000 with the condition of no contact and no weapons as well. Thank you.
Thank you. Response or any objection?
I remember once I was making an argument and in front of Judge Strong, and he was already, I think he was gonna dismiss the case or something. He said, and I was carrying on, and Judge Strong looked at me and he said, "Counsel, you gotta learn when to leave alone." So I was gonna regale you and go on and on and on, but I'll spare everyone and say thank you to APA Coyle, and we appreciate that, and so that's all I got.
Thank you, Counsel, and good to see you, sir. Mr. Horton, you've got good counsel here to represent you. You've surrendered yourself. I'll take into consideration no assault convictions. This, as stated by the people, took place in 2021, warrant not having been submitted and signed until 2023. It's an assaultive allegation, so I have concerns. So I'm going to set certain conditions, but I will follow both parties' recommendation. It will be released on a $10,000 personal bond. During this bond, and given these assaultive allegations, you are not to purchase or possess a firearm or any dangerous weapon that includes knives, no weapons. And you're not to have any contact with the complaining witness, Mr. Richards, and that's no contact of any kind, orally in writing, through a third party at their place of residency, employment, or through any forms of social media. No contact with the complaining witness while on bond. Is that understood? Thank you. Mr. Horton or counsel, any questions on court dates or bond conditions?
No.
All right, gentlemen, Mr. Horton, just have a seat. You'll get some paperwork on this matter from Officer Brownlee. I want you to speak with counsel regarding your under matter. Once you're finished interviewing, we'll handle that matter. And good to see you.
Thank you. I haven't seen you since you've taken the bench, and I knew you were on the bench, and I knew I was going to see you sooner or later. It's good to see you as well, Your Honor. and-
Good to see you. I hope it's all well with you. All right. Andre Clark. Good morning, DDC.
Morning, Your Honor.
Thank you. How are you?
Well, yourself?
I'm well. I'm okay. Thank you for asking. If we could bring, on the male side, we have Anthony Sims, if we could bring him first. But if we could bring the two females that we have capious warrants for on the female side first. Chief Judge McConico is waiting on them. That would be Beasley and Spradlin, number 12 on the list and number 5 on the list. If we could zoom in from the female side and bring those as well. Right now, a court would appreciate it. Thank you. Good morning, sir. One moment. Your name at the DDC?
Thanks, good night. Anthony Sands.
Okay. Have you spoke with counsel already? Okay. Go outside in the hallway. You spoke with them? Go knock on the door and let them know that you're ready and that we're going to represent you, okay? Thank you. Thank you. Good morning, Mr. Sims. One moment. Again for the female. Number 5, Beasley, female, and number 12, Spradlin, female.
Bradlin's not here, that's an MPOC.
Thank you. Appreciate you. So just Beasley. Well, they're going to be dialing in, so let's wait until they dial in. I don't have his, where's this file for number 7? I don't have Sims's file. Huh? So we have Horton, Navarre, Montgomery, Lewis. Next card. Okay, just one moment. We're gonna handle this one. Is that okay, counsel? All right. Mr. Sims, your full name? Thank you. This is case 25058-199, People State of Michigan versus Anthony Christian Sims, appearance for the people.
Thank you, Magistrate. Good morning. Good morning, Ms. Hickman. Steve Benson for the people, P71917.
Good morning, everyone. Kia Hickman on behalf of Mr. Anthony Sims, PA 6783. We're here for the purposes of arraignment. Your Honor, we ask that you enter a plea of not guilty. Defendant will stand mute and we wait formally.
Thank you. Good morning, counsel. You've advised your client of his constitutional rights. Is that correct?
Yes, Your Honor.
The court waive formal reading and a plea of not guilty, scheduling 2 court dates. Mr. Sims, you must attend both. Probable cause via Zoom, June 24th, 8:30, Judge Robbins, 36th District Court. That's via Zoom. You have a right to a preliminary examination in person, July 1st. That's also Judge Jefferson. June 24th, Judge Robbins, July 1st, Judge Jefferson. July 1st will be in person. Understood, Mr. Sims? Understood, sir? Thank you. Not guilty. Please enter on your behalf as the bond from the people.
Magistrate, this is serious, but it's non-assaultive. It's 1 count of a CCW. I don't see anything in terms of priors regarding this defendant. He's retained good counsel. It looks like he's taken it seriously. So at this time, we're not going to object to a personal bond. We would be asking for that condition, no weapons through the pendency of the case.
Thank you, counsel. Response, Ms. Hickman.
Yes, Your Honor. We'd be asking for a personal bond as well. Our client has no priors. He's actually a varsity sophomore at Central State. He was home on summer vacation, and he actually has plans to enroll into Eastern Michigan in the fall. He'll be living with his mother in Harper Woods during the pendency of this matter. And also, as you see, he has a lot of support. The people who were asked to join to watch on, usually that's his mom and also his mentor, who he's also employed with, where he works to assist and help younger students, seniors get into college as well. So this is a kid who, you know, is very deserving of a low personal bond. We believe that it'll be adjudicated in his favor.
Thank you, both. Mr. Sims, you have a good counsel, as you've heard, represent you today. I'm also unaware of any assaultive history. This is a serious, as stated by the people, non-assaultive allegation. I've reviewed the investigator's report. For those reasons, and given your age, I'm setting certain conditions as well. Given that allegations and what's been placed in the record, bond is going to be set at a $5,000 personal bond. Given the allegations before the court, you're not to purchase or possess a firearm or any dangerous weapon. And again, given your age, there is no use of alcohol and no illegal controlled substance while on this felony bond. You have no legal right to do it either. So, Mr. Sims, no weapons, no alcohol, no illegal controlled substance. You'll be released on a personal bond. Do you have any questions, sir, on your court date or bond conditions? Anything from counsels?
Nothing from me.
Thank you. All right, Ms. Hickman, good to see you. Take care. Good luck.
You too. Have a great day, everyone.
Thank you. Your name, sir? Thank you, Mr. Clark. You're here in case 25058-076, People State of Michigan versus Andre Terrell Clark. Appearances?
Lisa Coyle, appearing on behalf of the people.
Good morning, Under Justice Shive, on behalf of Mr. Clark, P number A1798, with formal reading and understands his constitutional rights and thank you.
Thank you. Good morning, Sheriff. For a waive formal reading and plea of not guilty, Mr. Clark, I'm scheduling 2 court dates, sir. You must attend both of them. Probable cause via Zoom, June 26th. That's via Zoom, 8:30, Judge Giles. You have a right to a preliminary examination in person, July 3rd, 8:30, 36th District Court, Judge Giles. Did you hear and understand those 2 court date and times you must attend, sir? Thank you. Not guilty, please enter on your behalf as the bond from the people.
And the people are recommending a $25,000 10% bond in this matter, as well as the condition of no driving whatsoever. I do see Mr. Clark being charged under the alternative theories. He is 21 years old. I am not aware of a criminal history, but I do note that at the time of the driving, his license was, per the IR, it was revoked. And in this matter, Your Honor, he admitted doing 60 to 65 miles an hour in a 30-mile-an-hour zone. He then struck a curb, caused both his left tires to flatten. He lost control of his vehicle and spun out the vehicle, striking the motorcycling. And the complaint in this matter, Ms. Killender was the passenger on the back of that motorcycle. She was launched off the back. It caused both of the passengers of that motorcycle serious injuries. She was, as to her serious injuries, it included a fractured skull as well as face. She's now deaf in her ear, a brain bleed, lacerated kidney, spleen, and liver. Also, she suffered from road rash, as did the driver, her fiance. Reason it's charged as a reckless is that because not only the speed of over twice the legal limit in that area, there was signage prior to where he had struck the curb, indicating that the speed limit was 30 miles an hour and that the freeway ended. By his reckless nature in driving, he allegedly disregarded all of those traffic control signs and struck the motorcycle. The people are asking for that 10% bond as well as that condition because we believe he's not only has proven to be a danger by striking Ms. Killender, he's also a danger to others on the road by when he's not supposed to be driving based on the status of his driver's license. He disregarded that. So in this matter, a personal bond will not suffice. There has to be something to back it up. And that's why I'm asking for the 10%. Because obviously when he lost the privilege of driving, and that the driving status was in revocation or expired, that he then chose to still drive a vehicle. So I'm asking for that because I believe based on these allegations, he's a danger. And so, and of course, I think I've mentioned the condition as well as no driving whatsoever. Thank you.
Thank you. And before I get a response, 1 second, Mr. Reagan, do you need to interview the MDOC, the Capias matter for Ms. Spradlin?
I do, just, I was waiting up for you to put me in a breakout room. That'd be great. Thank you.
So Ms. Spradlin, I'm going to put you in a private breakout room with your attorney. He's going to speak with you before the arraignment, and then we'll get started
Yes, sir.
sometime after, okay? Thank you.
Yes, sir.
Thank you, Mr. Reagan. I apologize for shy. Thank you. Response.
So, Your Honor, we understand that somebody was hurt here, and that is unfortunate. We understand that. But my client, Your Honor, he's 21. He's not on probation or parole or anything pending. He has no priors whatsoever. This is allegedly from April. It gets entered June 10th, and he's already in front of you. He walked in, and he asked his roommate who's here with him today in support to not only support him, but to also bring him here because he knows he cannot drive, and he did not drive here. He took the steps to ask somebody to bring him, and he is here in front of the court. He's a high school grad, Your Honor. We understand somebody was hurt, but Your Honor, when somebody is speeding, they get a ticket for speeding, whether it's 20 over, 30 over, whatever, it's a ticket. And this would have been a ticket, but somebody was hurt. And I'm not taking away from how serious the situation is, but they wouldn't be in jail, they wouldn't have a cash bond, it would be a ticket. But Mr. Clark understands that he cannot be on the road for any reason at all. And I think it's important that, yes, speeding is reckless, but there's no indication of any alcohol, any marijuana, any controlled substance, any texting and driving. The allegation here is the speeding, which is very dangerous on the road because it ends up in these kind of situations, unfortunately. However, most people just get a speeding ticket. So I'm asking the court to consider a high personal bond, absolutely no driving, and this is from April. I don't believe he's driven since. I think he's learned his lesson the hard way. I think, he took the steps to come immediately in front of the court right when this was signed. This was just signed on the 10th. Most times people don't even know that it got signed. He took the steps to ask somebody to bring him, not drive here, not make any excuses. And again, he's a high school grad with great community ties and family ties. So I'm respectfully asking the court to high personal, no driving, given that he has no priors whatsoever, assaultive or not, or in this nature, and there was no substances involved in this. But the speeding, yes, is serious. He knows that, and he's going to be doing everything he has to do to take care of all of this, Your Honor.
Thank you, counsel. Sir, raise your right hand. No. Yep, you swear from to tell the truth, whole truth, and nothing but the truth.
Yes,
You can say your name, please.
John Bordanowski.
Berdanowski. Good morning, Mr. Berdanowski. A few things. I appreciate you bringing Mr. Clark to court and driving him. My understanding, based on counsel's representation, is your roommates. Is that correct?
Yes,
Are you continuing to be roommates?
yes.
Okay. And if I were to release Mr. Clark as recommended by his counsel, just a question you can answer however honestly. Would you, as a responsible member of this community, agree to monitor him to the best of your ability and report any violations? I'm going to add certain conditions, and if he violates in any way, you would report it to the court
Yes,
at the best of your ability, and make sure the best of your ability he attends court dates. Is that a yes? Thank you. I appreciate that. You can have a seat. Thank you again. Mr. Clark, you have brought your roommate made decisions as indicated by counsel who's advocated well on your behalf. I've heard from the people and I share their concerns. These allegations are extremely concerning. You were driving allegedly at speed limits over double the speed limit, according to investigators' report and your own admission, resulted in an accident with substantial and concerning serious injuries. Some of them placed on the record by the people, but there's a brain bleeds, fractured face, lacerations, the liver, spine, or kidneys, multiple concerning injuries based on this allegation. Noted, Mr. Clark, you have, these are one misdemeanor and that's a 5-year felony allegation. I also take into consideration, as your counsels pointed out, this took place back in April. Warrant being signed on June 10th. I'm not saying that that's a lot of time for the people to submit it, but where I do note and take into consideration is that it did take place in the middle of April. It was signed June 10th, and as pointed out by your counsel, you're walking in 7 days later on June 17th. That's not all that common, Mr. Clark, being that it was an incident date over 2 months ago, or at 2 months ago, and within 7 days of the warrant being signed, you surrender yourself, and that's taken into consideration. You have no assaultive history. I have concerns regarding, as the people do, you being on the road at all. But I feel that I can properly monitor those conditions and protect the safety of the public with conditions less than a cash or 10% bond. Given your lack of history, what's been placed on the record, surrendering yourself, we have your roommate who's a responsible member of the community who's placed on the record. He's agreeing to monitor you and report any violations to the best of his ability. I feel comfortable setting bond for those reasons at a $50,000 personal bond. During this bond, and given these allegations, there's absolutely no use of alcohol, period. Is that understood? Speak up. Speak real loud for us. Thank you, because we're recording and I want you the record to reflect. No use of any illegal controlled substance unless doctor prescribed. Do you understand that? Speak real loud for us.
Yes, you're.
Okay. And absolutely no driving for any reason. Is that understood? No driving for any reason whatsoever. If you drive for any reason, regardless of the status of your driver's license, it's a violation of this bond. Is that clear? Did you hear those conditions? Okay, thank you. Mr. Clark, counsels, anybody, do you have any questions on court dates or bond conditions?
No, I just want to clarify one thing.
Just for the record, my client understands absolutely no driving, and he didn't drive here today. Although I just looked at paperwork, he has a valid license since May 11th. He took a driving skills test completion, and I just wanted the court to know that he took those steps and took that. But he still understands no driving, no matter what the status. But I think it's important the court knows that he's not having.
Yeah, and that it helps support the argument, Mr. Clark, that you're taking this seriously. You're taking steps to abide by the court's orders even before the court imposed them. So bond set for the reasons stated. Listen to the court. Good luck.
Thank you, Your Honor.
All right. DDC, if we could bring the female in, Chief McConico is waiting on the capias for Miss Beasley. If we could bring her in from the female side, please. And then Mr. Reagan, as soon as he gets here, what happened to the MDOC?
I don't know, we're ready, Your Honor.
Claudia, they zoomed away. Could you call them and tell them they need to come back? Here's the file.
And Your Honor, I am ready on the second matter from Mr. Horton whenever the court is.
Of course, ready. Come on up, Mr. Horton. One moment, sir, at the DDC. You'll be next. There's one more walk-in, I believe. Sir, state your full name.
Michael Allen Horton.
Thank you. Mr. Horton, do you have an opportunity to speak with counsel on this matter? Is that
Yes,
correct?
I did.
Thank you. This is on case 24045198198. People State of Michigan versus Michael Allen Horton, appearance for the people.
Lisa Coyle appearing on behalf of the people.
The sheriff on behalf of Mr. Horton, who is formal reading of his constitutional rights and to be on this president of court.
Thank you. Well, for a way formal reading and entertained not guilty, Mr. Horton, I'm scheduling a pre-trial date on this matter via Zoom, June 27th. That's at 9:00 a.m. Judge Bryant here at the 36th District Court. Understood? June 27th. That's Friday.
Okay.
Okay. Not guilty. Please entered on your behalf as the bond from the people.
Your Honor, no objection to a 5,000 personal bond in this matter, and I'd ask for the condition of only driving if he has a valid driver's license.
Thank you, Ikea.
No objections, and it's my understanding he has a valid license.
Okay, so Mr. Horton, you have a few things going on. We just arraigned you on another matter that was an assault allegation that had some age to it, as well as this does as well. This allegation took place in 2021. Warrant not had been submitted by the people and signed for 2024. It's a allegation that I believe as recommended by the people in defense, that can be proper to protect and ensure that you come to court with a personal bond as recommended after review the investigator's report. It will be set at $5,000 as recommended by the people. And also you surrendering yourself, no capious history. I'm not concerned about flight risk. during this bond as recommended by the people and given these allegations. No driving unless you have a valid driver's license. Is that
That
a
one, sir.
that's fine, Mr. Horton. That's if you don't, no driving.
Yes, sir.
Okay. Any questions on your court date or bond conditions?
No, sir.
APA, Ms. Coyle, anything further? Ms. Shine,
Nothing
anything?
further. I appreciate that. Thank you.
Welcome, appreciate you both. All right, have a seat, Mr. Horton. Officer Brownlee will take care of you from this point forward. All right, DDC, whenever you're ready. Thank you. You can unmute. What did they say, Claudia? What did that MDOC say?
I didn't find it.
Oh. No, MDOC zoomed away, so they're not on the camera. And then the females, they have a problem, so we're not ready on either. We need that, we're ready on that, but when Phil had stopped interviewing, they zoomed away. So we are ready. We just need them to zoom back in and we'll be ready. Because the females side is here. All right, thank you, DDC. If we could just, we have the female side in, we're just waiting on Chief to bring us. Ma'am, is that Miss Beasley?
Yeah, yes.
Okay, thank you, Ms. Beasley. Just one moment. The chief judge is going to join us and we'll handle your matter. Just wait on him. Thank you, sir. At the DDC, what's your name?
Harold Lewis.
Thank you, Mr. Lewis. Good morning to you. All right, you're here for a couple matters, Mr. Lewis, that you have warrants for your arrest for failing to appear. One moment. What's that? She was interviewed, then she. We put her in a breakout room, then she zoomed away. So they just need to call back in.
Yes. Thank you.
Thank you. Oh, no worries. Okay, so Mr. Lewis, you're here for a couple of reasons. We'll do them one at a time. First, you have a warrant for your arrest for failing to appear at the 36th District Court. On this matter, you'll receive a personal bond, no dollar amount, on scheduling a pretrial via Zoom, July 1st, 9 a.m., 36th District Court, Judge Perkins. You'll be released on a personal bond, no dollar amount. One moment. Claudia, what's this one? It's a ticket that was in here, but it's a domestic violence. All right, so Mr. Lewis, we're gonna hold off on that one, sir. We're gonna have one more matter. State your full name again. And then you can call chief. All right, thank you, officer. Appreciate you. One moment, ma'am, you're gonna be heard as soon as the chief judge joins us. Claudia, you can call chief whenever. Mr. Lewis, state your name again. Daryl Lewis, state your full name again.
Harold Lewis.
Thank you, appreciate you. And this is on case 2304537-1, People State of Michigan versus Daryl Lee Lewis, also known as Daryl Lewis, Daryl L. Lewis. Parents for the people.
Thank you, Magistrate. Steve Benson, P71917.
Thank
Judge
you, sir.
Miguel Brico on behalf of Mr. Lewis, P88379.
Good morning, counsel.
Good morning.
Thank you. As to the arraignment, sir?
Judge, I'm sorry. My client has been advised of his constitutional rights, waived upon reading the complaint, stands mute, requests a not guilty plea be entered on his behalf.
Thank you. Both court waive formal reading and a plea of not guilty. Recall the warrant, set aside capious. On this matter, Mr. Lewis, I'm scheduling a pretrial date via Zoom. You must attend. Now strike that. This will be an in-person. This is scheduled in person. You have to come down to the 36th District Court, 421 Madison on June 27th, Friday at 8:30 a.m. Understood, Mr. Lewis? In person, 8:30 a.m. Thank you. Not guilty, please, and on your behalf, recall warrant, set aside capious as the bond from the people.
Magistrate, we're just going to ask you to continue this. I think Judge Garrett was pretty clear regarding this defendant when he failed to appear. I have even 4 days prior to the failure to appear, he had revoked this defendant's bond. He does have a 2014 felonious assault conviction here being charged with the DV as well as the MDOT. So we're asking you to continue this.
Has he picked up anything or any capious or anything else that I should know about since this? Because this capious was, as you know, 23, November 7th of 23.
I don't have anything one way or another.
1 second. Respond, okay. Defense?
Judge, as you had noted, this case is stemming back from around 2023. Spoke to my client. As far as my office is aware, he has not picked up any new incidents with the criminal justice system from the initiation of this case until now. When asked why he failed to appear, Judge, he stated he had no idea about the court day and had just not showed up to that day. We expressed to him the importance of showing up to these court dates. He's committed to showing up to these court dates. I would ask this court to entertain a personal bond on the matter. I do understand that Judge Garrett had placed that cash bond. I'd be asking you to convert it today to a personal.
Thank you. And APA, first, I'd like to hear your argument on this. I do see what Judge Garrett on November 7th, 23 issued a remand. However, October 13th, less than a month before, he gave a 5,000 personal bond and set an order to modify, remove house arrest, and order the bond conditions of bond conditions that defendant be on home confinement be removed. So just less than a month before, he put him on a personal bond, took off his tether, removed the conditions, and then less than a month later, he remanded him. And now we have nothing since then. So it looks like Judge Garrett thought that a personal bond was appropriate, and then he missed one more court date and went to a remand, and now we don't have anything since then. So I'm inclined to set a personal with monetization, but what's your opinion?
I'll speak to it. Now Judge Ramsey Heath, who was the magistrate, I believe at the time, ended up first issuing a cash bond here for the 5,000 with tether house arrest. I don't think it was Judge Garrett that ended up converting this to a 5,000 personal. I believe it was at redetermination. Where
I see an order. I don't mean to cut you off, but I see a handwritten order from Judge Austin Garrett on October 13th, 2023, where it's handwritten and signed by Judge Garrett, modifying and removing the bond as stated.
But I have 4 days prior to that at redetermination, Judge McConico lowering it to 5,000 person. So I mean, we may both be right, magistrate, but my date.
I see that as well. I have McConico's October 9th. I see his as well, October 9th, that he lowered it to a personal. And then then it was probably in front of
So I think Judge Garrett's order was academic. It was already a $5,000 personal. Judge McConico gave him.
I don't mean to cut you off, but sorry, ATA. But Chief McConico at that point put a GPS tether requirement, house arrest, allow travel for court medical only. And then Judge Garrett took that off. So he modified Chief's. So Chief McConico put that 5,000 personal with the tether requirement. Then Judge Austin Garrett, a few days later, kept the 5,000 personal, removing the tether and house arrest.
I have 2 dates. I have an 11/3/23 where Judge Garrett revoked bond, and then 4 days later he remanded this defendant. We can see the allegations. Magistrate, I have too much respect for you to go back and forth on this. He was originally given a cash bond. These were serious allegations. He has a prior assaultive past. If I find out the defendant walked himself into the DDC instead of being arrested for him to be in front of us, then then maybe possibly I could understand why a personal bond, but he was originally given a cash bond. He was given, a tether house arrest. We don't see that too often in domestic violence cases. But with the history, with now the capious history, with the allegations, magistrate, I'm going to stick to what I was requesting. But again, I respect you too much to go any further with this.
APA, same respect extends your way, and I don't mean to get into a back and forth. I was just picking your brain and using you as a resource to get some information. So it was more of me just trying to better understand what was going on and get your opinion as opposed to a back and forth.
I appreciate it.
All right. Anything further from defense?
Yes, Magistrate, I appreciate the dialogue back and forth about the case. I just wanted to state on behalf of my client's record, any amount of bond that would be imposed or would be continuing is going to be unaffordable for him. If a prior court or a prior judge saw fit that some monetization was suitable to ensure his appearance in court, I wouldn't have an objection to a monetization requirement if this court was going down that route. I of course object to it at times just because of how difficult it is for our guys to sometimes leave the DDC waiting on that tether. But Judge, as far as the monetary amount, that's our main goal. We never want somebody waiting in pretrial detention simply because they can't afford that amount. I would request this court to convert it to a personal bond. No objection to the narrowly fitted monetization requirements that this court may deem fit.
Thank you. Mr. Lewis, you have, this is a very serious allegation, assaultive allegation. You have multiple capias on this matter. I've reviewed the investigator's report. They're concerning allegations, not including assaults, but also allegations of injury and threatening to do harm when released. This incident took place back in 2023. You've misquoted a number of, or the incident date took place in 23. The last bond was issued at November 7, 23. 23 is a remand. I placed on the record the back and forth between the bonds. That it went from a personal bond with monetization set by the chief, according to what Chief Judge on October 9th, 2023. And then on October 13th, 2023, Judge Austin Garrett removed the condition of house arrest, the tether, and continued the personal bond, only for Mr. Lewis to failing to appear on November 7th, 2023, where Judge Garrett issued a remand. I do have concerns regarding your failure to appear, given a date of this allegation, as well as lack of any history since that point in time, and they're charged as misdemeanors, 293-day misdemeanors. My concerns are highly regarding your intention to appear, and I have concerns regarding the safety of the complaining witness, given allegations of threat and as well as allegations of assault and with injury. For those reasons, I am going to set bond at a $100,000 personal bond with the following conditions. No use, you're not to purchase or possess a firearm or any dangerous weapon. Prior to being released, you will be filled with a GPS tether, placing you under house arrest, Mr. Lewis. You're not to go anywhere unless court ordered. During this bond, you're not to go anywhere near the West Grand Boulevard address, and absolutely no contact with the complaining witness, Miss Aiken, and that's no contact of any kind, orally and writing, through a third party at their place of residency, employment, or through any forms of social media. Mr. Lewis, if you go anywhere near Miss Aiken or the West Grand Boulevard, or leave your home for any reason, less court ordered or medical, it's a violation of the court's bond, subject to get you picked up without a warrant and have your bond conditions forfeited and or revoked. One moment, please. What is it? One moment. Oh, what's the other case? What type of case? All right, we're recalling this. I'm holding on this one because I was just informed that Mr. Lewis has another case as well that they're going to be brought up. So I'm going to hold off the final decision on that matter, and then they're bringing another one. So hold off on the final decision on that one. All right, thank you. Mr. Lewis, you're all set. We're going to recall this once we bring another case. And my understanding, it may be a domestic violence case, so that could change my opinion. You got to hold the chief. Huh? Okay, thank you. All right, Miss Beasley and Miss Spradlin, thank you for your patience. The chief judge is on the way, and as soon as he gets here, they'll handle your matters. Thank you for your patience. DDC, if you could bring another mail, please. All right, this one, it says 2:30 p.m. and I don't even know how, are we supposed to call her? Are they calling or, and why do we have that one? Sir, your name? What is it? William Logan? All right. Good morning, Mr. Logan. You're here on case 240580601, People State of Michigan versus William Eddie Logan, identifies the complaints defendant one, also known as William E. Logan, William Logan. Appearance for the people.
Thank you, Magistrate. Steve Vincent, P71917.
Judge Miguel Brico on behalf of Mr. Logan. Judge, my client's been advised of his constitutional rights, waives a formal reading, stands mute, respectfully requests a not guilty plea be entered on his behalf.
Thank you. For waive formal reading and a plea of not guilty, Mr. Logan, I'm scheduling 2 court dates. You must attend both of them. Probable cause via Zoom, June 25th, Wednesday, 8:30, 36th District Court, Judge Giles. You have a right to a preliminary examination in person, July 2nd, 8:30, 36th District Court, Judge Giles. Did you hear and understand those 2 court date and times you must attend, Mr. Logan? Mr. Logan, understood?
Yes, sir.
Thank you, sir. Not guilty, please entered on your behalf as the bond from the people.
Magistrate, this is serious, but it's non-assaultive. I also have an incident date that's over a year ago, albeit a warrant that was entered a month following the incident date. At this time, we're not going to be objecting to a personal. We would ask for a condition, no drugs through the pendency of the case.
Thank you, counsel. Response.
No objection to either of those conditions, Judge.
Thank you. One moment. This is a very serious allegation on assault of Mr. Logan. I have reviewed your criminal past, and you have a number of felony convictions and assaultive and concerning a couple, Mr. Logan. This is a non-assaultive allegation took place in 24. I've reviewed the investigator's report. After recommendation and advocacy from both parties, I'm setting bond as they've recommended at a $20,000 personal bond. During this bond, Mr. Logan, given allegations of illegal possession and delivering cocaine, you are not to purchase or possess any illegal controlled substance. Is that understood, Mr. Logan? Do you have any questions on your court date or bond conditions, sir? Mr. Logan, any questions? All right, you're all set.
I would love to work with you. I can't even talk. I was like.
Your name, sir?
Spraggins.
Joaquin Spraggins? One moment, Mr. Spraggins. All right, one moment. One moment, sir. There what? I didn't know this one was an OCJ that we have to call into at 11. It's on the inside. No. Mr. Montgomery?
Yes, sir.
Mr. Reagan, are you going to be interviewing Mr. Montgomery?
Yes, Your Honor.
Thank you, Mr. Montgomery. I'm going to put you in a private breakout room with your attorney. He's going to speak with you and we'll proceed after you talk, okay?
Sure will.
Thank you. All right, Mr. Spraggins, thank you for your patience. You're on case 23057-312, People State of Michigan versus Joaquin Robert Spraggins, appearance for the people.
Mr. Coyle appearing on behalf of the people.
Miguel Brico appearing on behalf of Mr. Spraggins. Judge, my client's been advised of his constitutional rights, waives a formal reading of the complaint, stands mute, respectfully requests a not guilty plea be entered on his behalf as to all counts.
Thank you both. Court waive formal reading under plea of not guilty. Mr. Spraggins, I'm scheduling 2 court dates, sir. You must attend both. Probable cause via Zoom, June 25th, 8:30, 36th District Court, Judge Giles. You have a right to a preliminary examination in person, July 2nd, 8:30, 36th District Court, Judge Giles. Did you hear and understand those 2 court date and times you must attend, Mr. Spraggins? Speak up, please. Thank you, sir. Not guilty. Please enter on your behalf as the bond from the people.
Your Honor, this is non-assaultive. It's back from October of 22. But I do note that Mr. Spraggins has, to my knowledge, over 30 felonies for theft and so forth. This is non-assaultive, like I said. So for that reason, and it's old, people are requesting a 20,000 personal bond, Your Honor.
Thank you, Amy. Response?
Judge, no objection to a personal bond. It has been indicated to me that Mr. Spraggins did walk himself or turn himself into the DDC, as far as my knowledge pertains.
Thank you. And Mr. Spraggins, that's the court appreciates and takes into consideration you surrendered yourself to address these allegations that took place in 2022, warrant having been submitted and signed in 2023. And here we are in 2025. This does have age to it. You have a large stack of convictions, of felonies, as the APA has pointed out. This is a non-assaultive allegation, given a date. You surrendering yourself as representation from both parties. Bond will be set as they've recommended, Mr. Spraggins, $20,000 personal bond. During this bond, you are not to have any contact with the complaining witness, Mr. Algohim. No contact means no contact of any kind, orally and writing through a third party at his place of residency, employment, or through any forms of social media. No contact with the complaining witness, Mr. Spraggins. Is that understood? Any questions on your court dates or your bond conditions, Mr. Spraggins? No, you're all set. Thank you.
I'm floating, I can't get up. Lieutenant Brady is here. Wow. Lieutenant Brady.
Is that all the mails? Yes, Your Honor. All right, thank you. We're just waiting on the chief for the female side. Appreciate your help. Thank you.
What is that? Yeah. Oh, but I walked out with everybody might come on you.
Judge McConaughey is not here. I can get my other two ladies in, if you don't mind.
Okay, go ahead. Yep, I'll let him know. I'll let you know when he gets here. Thank you. We'll get those other two ladies in. Appreciate you, sir, Officer Green.
No worries. Now you know you got some other wheels here. Listen,
Are you ready? I'm missing. Okay, ma'am, state your name. One more time, please. Okay, I don't, you need to stop chewing your gum or whatever you're chewing, please. Did you say Markeisha Archer? Markeisha Archer?
Yes.
Okay, good morning, Miss Archer. Stop chewing the gum. You have to spit that gum out or whatever. Okay, Miss Archer, you're here for a couple of reasons, ma'am. We're gonna go through them one at a time. So if you have any questions, let me know. First, you have a number of matters you have warrants for your arrest for failing to appear at the 36th District Court. On these matters, you'll receive a personal bond, no dollar amount. And you have a pretrial you must attend via Zoom, July 2nd, 1:30 p.m., 36th District Court, via Zoom, courtroom 533. Understood, Miss Archer?
Yes.
Thank you. As with any criminal matter, you have a right to remain silent. Anything that you say orally or in writing can and will be used against you in a court of law. You do have the right to an attorney present at questioning and at all future proceedings. If you cannot afford an attorney, the court will appoint you one at the public's expense. Did you hear and understand your rights, Miss Archer? Thank you, ma'am. This is in regards to ticket numbers SP 107-8897, April 21st, 2020. Count 1, drive unregistered untitled motor vehicle. Count 2, no insurance, misdemeanor on a 2014 Buick. Count 3, drive while license suspended. SP 1085584, May 22nd of 2020. Count 1, drive while license suspended. Count 2, improper plates. Count 3, fraudulent false insurance information. SP 1085622, May 22nd of 2020. Drive unregistered or untitled motor vehicle. SP 1085651, May 22nd of 2020, no insurance, misdemeanor on 2014 Buick. SP 1112782 on October the 3rd of 2020. Count 1, drive unregistered or untitled motor vehicle. Count 2, no insurance, a misdemeanor on a 02 Chevy. Count 3, drive while license invalid or improper license. Complaint U 1666014, Saturday, April 12th, 2014. Loitering in a place of illegal occupation near Joy Road, Blind Pig. 17386-746, October 27th of 2017, improper plates. And ticket numbers 183835556. April 26, 2018, count 1 improper plates, count 2 insurance never acquired on a 2013 Ford, count 3 driveway license suspended. These are all misdemeanor allegations that carry up to a $500 fine and or 93 days in jail as a maximum fine and penalty. Recall the warrant, set aside capias, and a not guilty plea on your behalf. As a reminder, Ms. Archer, you'll have a personal bond on these matters, and you'll have a pretrial via Zoom, courtroom 533, 36th District Court on July 2nd at 1:30 p.m. Understood? Thank you, ma'am. All right, so you have one additional matter. We have a warrant for your arrest, so state your full name again. Thank you. This is case 22044-901, people state of Michigan, Markeisha Archer, also known as Selena Midgets, Markeisha NYA Archer. Appearances.
Lisa Quote, hearing on behalf of the people.
Judge Miguel Brico appearing on behalf of Ms. Archer. Judge, my client's been advised of her constitutional rights, waives the formal reading the complaint, stands mute, requests a not guilty plea be entered on her behalf.
Thank you both. Ms. Archer, await formal reading, recall warrant, set aside capias. I'm scheduling an in-person hearing. You must come down to the 36th District Court, 421 Madison, June 27th, Friday. Judge Garrett at 8:30 a.m. Understood? For a pretrial. Thank you. And to let both parties know that current bond, from what I see, was set by Judge Garrett November 17, 2023, where it's a $750 cash surety indicated on the capias and judgment. Defendant must post bond, and it's highlighted for the people.
Your Honor, the people would request that bond to remain in place. I do note, if the court's going to reduce it, I'm asking for a tether. I do note this occurred back in June of 2022. She's had 3 failures to appear, 3 or 4 on this matter. She also forfeited a $500 bond. So the likelihood of her coming to court is low. So for those reasons, Your Honor, because she has failed to come and she has forfeited her $500 bond, I'm asking you to keep that bond in place in an alternative attached tether. Thank you.
Thank you. Response.
Judge, on behalf of Ms. Archer, I would object to keeping, well, I would request for you to convert this capias cash surety bond to a personal bond, Judge. We're in a situation where we spoke with our client. We discussed what's going on. We discussed why she needs to show up to court. And Judge, my client has a multitude of issues going on health-wise, both mental and physical, that may lend some credence to why she has these failures to appear. In addition to that, Judge, just to touch on these specific allegations on why we're here, it's a case stemming back from a while ago. I do have in the incident report that's in my hand that the complaining witness does not want to testify, that the complaining witness reached out to the OIC and expressed that they do not want to press charges. So likelihood of conviction on this matter is.
When was that? What date was that?
Judge, I just see on the last report, on the last page of the investigator's report, it says that the complainant, and his name is listed, will not testify to info and belief. The complainant called and stated he's not pressing charges and to let the defendant go. I don't have a date.
Thank you.
No
I
problem.
see that. I thank you. Continue.
No problem. So I just know that that's a factor we consider under MCR 6.106. I would request a personal bond on the matter, give Ms. Archer one more chance to show up to court. I don't have a specific objection to monetization. I would leave it in the court's discretion. I understand we have a few things going on in the past. I would just ask this court to consider the fact that the tether itself imposes a certain type of impediment and leaving the jail sooner than later, and would leave that at your discretion, Judge.
Thank you, Ms. Archer. The reason I asked what date that was, and according, I see it's in the investigator's report. So Judge Garrett knew about that information when he set this bond, and it set multiple bonds. So this is not any new information to the judge. And you continue to miss court, Ms. Garrett, or Ms. Archer. Judge Garrett sets bond, you miss court. You've missed court at least 3 times according to the people, once forfeiting a bond. And now we have you yet again missing court. And DDC, please mark Ms. Archer's file medical for the reasons stated by counsel. Thank you. So I have concerns regarding your intention to appear, as you've failed to do so on a number of occasions, even forfeiting a bond. As I've stated, Judge Garrett at this point issued it for $750 cash surety and highlighted defendant must post bond. So I'm guessing he shares similar concerns, have given a cash surety bond after issuing personals, as well as a $500 cash surety on June 9th, 2022, which apparently he forfeited. Given her multiple capias, Ms. Archer, I don't see any other way to ensure that you appear as to continue the cash bond set by Judge Garrett. And so that is going to be continued at $750 cash surety. Given the allegations, assaultive allegations against this complaining witness, you are not to have any contact with the location of Seabourn Street, Detroit, Michigan. Stay away from that area or premises. And absolutely no contact with the complaining witness, Mr. King, and have no contact of any kind, orally in writing through a third party at their place of residency, employment, or through any forms of social media. No contact with the complaining witness, Mr. King. Counsel, is that an unaffordable bond?
Yes, Judge, it is.
All right, thank you. And based on that representation, I'm scheduling unaffordable bond redetermination hearing Ms. Archer in front of Chief Judge McConicle on June 19th. That's 2025, 9 a.m. via Zoom. If you're unable to post bond, you'll see the Chief Judge and have an opportunity to re-argue bond at that point. Do you have any questions, Ms. Archer, on your court date or bond conditions? Okay, you're all set. The Chief Judge is here. I think DDC, if we could bring back Ms. Bees. Okay, good morning, Chief. We're ready on two matters for you. Good morning. We have one in the MDOC that's ready on Miss Alicia Spradlin. Let me know whenever you want to call the case.
Call it, please.
Thank you. It's 2305778, people state of Michigan versus Alicia LaRae Spradlin. Ms. Spradlin, state your full name.
It's Ashley LaRae Spradlin.
I apologize. Ashley LaRae Spradlin, appearances.
Thank you, Magistrate. Good morning, Chief Judge McConicle. Steve Vincent for the people, P71917.
Good morning. Good morning, Judge Miguel Brico on behalf of Ms. Spradlin, P88379. Judge, my client's been advised of her constitutional rights, waives the formal reading of the complaint, stands mute, respectfully requests a not guilty plea be entered on her behalf.
Not guilty plea will be entered. Magistrate Capella, what are the charges and what is the current bond?
The charge, Your Honor, is one count of stolen property, receiving and concealing a motor vehicle took place July 7th, 2023. The current bond is $30,000 cash set on July 26th of 2023.
Argument after bond.
Thanks, Judge. I'm just going to give you everything that I have, and then I'll let you just take over. So she was on probation at the time of this offense for felony controlled substance. She had been sentenced March of 2023. I have an offense date here of July 7th of 2023. So only about 4 months into probation, she picked up this offense. Following her failure to appear, she has picked up two other cases, one of which she was sentenced on June 26th of 24, ended up getting probation from the Honorable Judge Matthews over in Oakland County. Additionally, she was sentenced earlier this year to a UTA of all things because she's being charged with an RCSP motor vehicle here. She ended up getting 1 year, she got 1 year jail on that. She got credit for 86 days. She's going to be in the MDOC, at least based on my math, 279 days from January 21st through August sometime, which is kind of close in time. But I don't have any reason why she would have failed to appear in this particular matter. Actually, her attorney, 2 days prior to this failure, there was an exam that was scheduled. He said the defendant just got the days mixed up. 2 days later, it was set and she failed to appear. So, Judge, it's $30,000. You know Judge Giles and what he does. We'll leave the rest up to you. I just wanted to give you all that information.
Judge, on behalf of Ms. Judge, on behalf of Ms. Spradlin, it's my understanding that she has quite some time remaining on her current sentence that she is currently serving time for. I would be requesting on this matter, Judge, a nominal bond.
Do we got ID?
Chief Judge, you may be speaking. I don't think we can hear you. At
Can
least,
someone mute some of the, I can't hear you guys. Can you hear me now?
yes.
Okay. Bond will be reduced to 30,000 personal. Thank you.
Thanks, Judge.
Thank you.
All right.
Ms. Bradlin, any questions? You have a personal bond. Your next two court dates. You have a personal bond, Ms. Bradlin, and I'm scheduling a probable cause conference, June 26, 8:30 via Zoom, Judge Giles, June 26. Judge Giles, you have a right to a preliminary examination in person, July 2nd. Judge Giles, both at 8:30. You have a 30,000 personal bond. Understood, Ms. Bradlin?
Yes, sir.
Okay, good luck, ma'am. And then from the DDC, Ms. Beasley, state your full name.
I'm finished.
Thank you. And Ms. Beasley, this is on case 1505696, People's State of Michigan versus Therese Beasley. Appearances.
Lisa Coyle appearing on behalf of the people. Good morning.
Good morning, everyone. Miguel Brico appearing on behalf of Ms. Beasley. Judge, my client's been advised of her constitutional rights, waives the formal reading of the complaint, stands mute, requests a not guilty plea be entered on her behalf as to all counts.
Not guilty plea will be entered. What are her charges in the current bond, please?
The charges are count 1, controlled substance delivery and manufacturing less than 50 grams. Count 2, controlled substance maintaining a drug house from February 15th, 2015. The bond is 1,000 cash or surety, June 3rd, 2022. Failure to appear on Zoom hearing.
Madam Prosecutor.
Your Honor, this is a non-assaultive matter. She did not appear back from June of 22. No objection to putting the original bond of a personal bond, but I am asking for a tether in this matter. Thank you.
On behalf of the defense.
On behalf of Ms. Beasley, no objection. We would recommend the recommendation of a personal bond on the matter. Judge, when it comes to the tether matter, Ms. Beasley did state to me that she didn't have a way to get to court and didn't know how to use Zoom at the time. We have since had discussions on the importance of showing up if you do not know how to use Zoom for your court date. This matter does stem back quite some time ago. It is over, I believe, 10 years now. And Judge, if we look at the specific allegations actually made against Ms. Beasley, it appears that they're charging her with the delivery, manufacturing, maintaining of a drug house situation, which, to be frank, if we look into it, I'm not going to litigate it. Should have never been charged that way. It seems wrong to do that in this case. The tether requirement is the one thing I have an issue with, Judge. It's hard for our clients to exit the DDC, sometimes waiting on that tether. It's hard for them sometimes to tether at a place. I would ask this court to just consider the ramifications of that on our client's personal liberties, and also in trying to, fulfill the obligation this court has with her appearing to court. So I'll leave that at your discretion, erring on the side of an objection to that tether, Judge. Thank you.
Bond will be reduced to 1,000 personal with a GPS tether with 10 p.m. to 6 a.m. curfew. Thank you.
Thank you, Chief. Have a good day, sir.
Thank you, Chief.
All right.
All right, Ms. Beasley, I'm scheduling 2 court dates on this matter. You have a personal bond. You'll be through with the tether as stated, 10 p.m. to 6 a.m. curfew. Probable cause via Zoom, June 26th, Judge Giles, 8:30. You have a right to a preliminary examination in person, July 2nd, 8:30, both Judge Giles. Understood, Ms. Beasley?
Okay.
All right, good luck, ma'am. Okay, your name, ma'am? Did you say Carolyn McNeil?
Yes, sir.
Good morning, Miss McNeil. All right, and then DDC, once we're finished with Miss McNeil, if we go back to the mail side, we have Daryl Lewis that we need to finish up. They brought additional case, please. Daryl Lewis on the mail side. Thank you. Yep. For which one?